Washington Legal Foundation. I'm Glenn Lambie. I'm Chief Counsel of the Foundation's Legal Studies Division. And for those of you who are joining us online, thank you for joining us as well. For those of you not familiar with the Foundation, we are in our 38th year of public interest law advocacy and education on a pretty wide range of issues. We sort of do three things under one roof. We have started out as a litigating organization, filing amicus briefs and original litigation in the federal and state courts, regulatory comments, requests for rulemaking, and other related activities. We added on our publishing side 25 years ago called the Legal Studies Division, which puts out papers on a pretty wide range of issues. And we also have a pretty aggressive communications side to us as well, in addition to putting on programs such as this, web seminars, we run a blog, we do a lot of issue advertising, op-ed writing on issues of interest to the free enterprise system and innovation. And we're pleased to be focused on a topic today that I think fits into cuts across a lot of areas. And I think in this context, it's one of the more interesting ways to talk about the concept of standing and harm. In fact, the need for harm is a trigger for regulatory action, and access to the judicial system is really a bedrock principle in any democracy governed by the rule of law. For U.S. courts, the requirement is set out clearly in Article 3 and the case and controversy requirement. On the regulatory side, for instance, the Federal Trade Commission's authority over unfair and deceptive acts and practices is constrained by an element of harm that the Commission interprets from FTC Act Section 5. How legislators, courts, and regulators define harm, then, is a critical threshold question that can have far-reaching impact on regulators and courts' use of dwindling government resources and on the regulated community's decision to invest and innovate. Finding an objective definition of an inherently subjective term like harm becomes even more complicated in the context of another subjective concept, privacy. Those difficulties are further compounded when you add in the desire of people to be free not only from in-person privacy invasions, but ones that occur through or with the use of computer devices. We are proud to have brought together a group of speakers whose work involves not only thinking about what online privacy harm means, but also taking action on those thoughts. We've asked Commissioner Ohlhausen to start out today to address not only the broad concept of online privacy harm, but also put those thoughts into the more specific contexts of things like the Obama administration's Consumer Privacy Bill of Rights and the way that federal courts have interpreted the concept of harm in privacy and data breach-related civil lawsuits. We're going to be taking questions from our online audience today, and if you want to email those to interactive@wlf.org, I will address those to the speakers. Starting off today is the Honorable Maureen Ohlhausen, who is a commissioner with the Federal Trade Commission. She was sworn in on April 4th, 2012, to a term that expires in September 2018. Prior to joining the commission, she was a partner at the law firm Wilkinson, Barker & Nauer. She previously served at the commission for 11 years prior to that, most recently as director of the Office of Planning and Policy from 2004 to 2008, where she led the FTC's Internet Access Task Force. Following her today will be Katherine Armstrong, who's counsel at the Washington, D.C. office of the law firm Hogan, Lovells. She joined the firm after a 30-year career at the FTC. Her wide-ranging experience at FTC includes work on the Fair Credit Reporting Act, Section 5 of the FTC Act, and privacy issues. As a senior attorney in the Division of Privacy and Identity Protection, she led investigations, settled law enforcement actions, and worked on rulemakings and other policy matters. Following her will be John Morris, who is the Associate Administrator and Director of Internet Policy at the U.S. Department of Commerce's National Telecommunications and Information Administration. The office he heads handles a broad range of Internet and telecommunications policy issues, including implementation of the Obama administration's Consumer Bill of Rights. Before joining NTIA in 2011, Mr. Morris was General Counsel of the Center for Democracy and Technology, and also CDT's Director of Internet Standards, Technology, and Policy Project. Finishing up today will be Adam Thierer, who is a Senior Research Fellow with the Technology Policy Program at the Mercatus Center at George Mason University. He specializes in technology, media, internet, and free speech policies, with a particular focus on online safety and digital privacy. His latest book is Permissionless Innovation, the continuing case for comprehensive technological freedom. Commissioner Ohlhausen, if you could get us started.
Well, I'm glad to be here at the Washington Legal Foundation and with all of you this afternoon. I had the honor of authoring the foreword to one of your recent monographs on the topic of data breaches, and I'd recommend this monograph universally or unreservedly It's a clear and practical guide on how to prepare for and respond to data breaches. But before I start, I'll give my usual disclaimer, which is that the views are just my own and not necessarily those of the Federal Trade Commission. So when we talk about privacy, what are the relevant harms? Which of these harms can be solved by market forces or social norms? Which are best resolved in court? And which ought we seek to address through regulation? Today, I'll first describe how the FTC evaluates harm in its privacy enforcement. Then I'll talk briefly about the administration's Privacy Bill of Rights and how it identifies privacy harms. And finally, I'll discuss some of the recent court cases on standing related to privacy harms and the extent to which these cases inform policymaking. When considering how the FTC conceives of privacy harms, there are really two questions. The first is the descriptive question. What harms does the FTC have the authority to address? And then second, the related but distinct normative questions. What harms should the FTC address? And I'd like to offer brief answers to each of these questions. So the FTC enforces a number of laws related to privacy, including the Truth in Lending Act, the Fair Credit Reporting Act, the Children's Online Privacy Protection Act, just to name a few. However, the core of the FTC's privacy enforcement authority is Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices in or affecting commerce. The FTC has used both authorities, unfairness and deception, to protect consumer privacy. But the conception of harm differs under these two approaches. So our unfairness statement says that an act or practice is unfair if it causes substantial harm that's not outweighed by any offsetting consumer or competitive benefits, and which the consumer could not have reasonably avoided. The statement specifies that the Commission, and this is a quote, is not concerned with trivial or merely speculative harms. In most cases, a substantial injury involves monetary harm. Unwarranted health and safety risks may also support a finding of unfairness. Emotional impact and other more subjective types of harm, on the other hand, will not ordinarily make a practice unfair, end quote. So in the context of privacy, these types of substantial harms are more likely to occur when the information involved is sensitive, such as financial or health information, precise geolocation information, or information about children. Now turning to the FTC's deception authority. Deceptive practices are material misrepresentations or omissions likely to mislead a reasonable consumer. Now, harm is not an explicit element of deception. However, as the FTC's deception statement explains, quote, a finding of materiality is also a finding that injury is likely to exist, and injury and materiality are different names for the same concept, end quote. So a representation is material if a consumer would have chosen differently but for the deception. The Commission considers certain categories of information presumptively material. For example, the FTC presumes that express statements to consumers are material. Otherwise, why would a business have made them? Similarly, the FTC presumes the materiality of claims that involve health and safety. Now, these presumptions can be rebutted by additional evidence. In cases where there is no presumption, the FTC must provide evidence showing that, but for the deception, consumers would have acted differently. Now, the injury in deception is the frustration of consumer choice. Note that this is the injury for purposes of determining liability. It's not the same as the damage that consumers may have suffered. The legal reach of the FTC's authority is larger than the set of cases that it would be prudent to bring. Because the FTC's ultimate goal is to maximize consumer welfare, there are some, perhaps even many, cases that even if we could bring as a matter of law, doing so would be a waste of our limited resources. Indeed, a recent FTC case called Nomi Technologies, I believe, falls into this category. So Nomi was a startup company, and it offered retail merchant clients aggregate data analysis about consumer traffic in the merchant's store. Nomi's technology generated this analysis by hashing and storing and subsequently tracking the publicly broadcast MAC address on consumer smartphones. Nomi provided this service as a third-party contractor, and it had no direct relationship with consumers. And as a third-party contractor collecting no personally identifiable information, NOMI had no obligation to offer consumers the ability to opt out. Yet, since the service started, NOMI has offered all consumers the opportunity to opt out globally. And for a time, NOMI's privacy policy stated that it, quote, pledges to always allow consumers to opt out of NOMI's service on its website, as well as at any retailer using NOMI's technology, end quote. And as I've already noted, NOMI did offer a global opt-out on its website. However, none of NOMI's retail clients offered consumers the opportunity to opt out. Thus, NOMI's privacy policy was partially inaccurate. Now, a majority of the commissioners supported a complaint alleging that NOMI's inaccurate express statement in its privacy policy was deceptive, and they imposed a settlement subjecting the company to a 20-year compliance order. I dissented from the complaint and the settlement in this case. The evidence suggested that consumers who wanted to opt out used the functioning global opt-out, and thus NOMI's partially inaccurate statement likely harmed no consumers. By bringing this case, the majority applied a de facto strict liability approach to a young company that attempted to go above and beyond its legal obligation to protect consumers, but in doing so, erred without benefiting itself. And my concern is that the majority's decision in this case discourages companies from doing any more than the bare minimum on privacy. And such disincentives will ultimately leave consumers worse off. So, as I've said, the evaluation of harm is a core part of the FTC's general approach to privacy enforcement, though we may sometimes reach different conclusions on particular cases. Yet, although our enforcement focuses on harm, the most common approach to privacy, the Fair Information Practice Principles, seeks to protect privacy primarily by limiting the collection and retention of data. FIPS provides useful tools for protecting consumer privacy, but these tools cannot do everything. And indeed, there's a growing consensus that protecting privacy by focusing on collection and retention is not sustainable in the face of technological change. In fact, the White House's Big Data report concluded that, quote, focusing on controlling the collection and retention of personal data, while important, may no longer be sufficient to protect personal privacy, end quote. The related PCAST Big Data report put an even finer point on it, saying, a policy focus on limiting data collection will not be broadly applicable or a scalable strategy, nor one likely to achieve the right balance between the beneficial results and unintended negative consequences, such as inhibiting economic growth, end quote. Now, one promising approach to address this mismatch is a greater focus on evaluating what uses are likely to cause real harm to consumers. For example, the Fair Credit Reporting Act limits how companies can use data, however that data was collected, to evaluate consumer creditworthiness, insurance eligibility, and potential for employment, and renter background checks, for example. And I believe the FCRA's use-based approach may provide a useful model for addressing wider consumer privacy concerns. Now, having described the FTC's conception of privacy harms and highlighted the importance of focusing on a use or harms-based privacy approach, let me compare it to the conception of privacy harm in the President's Privacy Bill of Rights. Now, this draft bill appeared to please no one, in my opinion. Industry said it imposed unworkable burdens and vague restrictions, while privacy advocates said it contained a huge self-regulatory loophole that would allow companies too much latitude. I think most people agree that the legislation has a very low chance of becoming law, but it remains instructive about the administration's thinking on privacy. So how does the White House's bill describe privacy harm? It says, quote, privacy risks means the potential for personal data on its own or when linked to other information about an individual to cause emotional distress or physical, financial, professional, or other harm to an individual, end quote. So note some of the key differences with the FTC standard. First, the definition of privacy risk includes emotional distress, which is a kind of subjective harm that the FTC's unfairness statement specifically disavows. And the catch-all other harm likewise sweeps in conduct that would not be a violation of the FTC Act. The bill imposes various notice and disclosure and data deletion and other obligations on companies in proportion to this privacy risk, and consistent with context. Now, when companies attempt to determine their responsibilities under the law, such an open-ended subjective conception of harm raises significant challenges. Indeed, it would appear to require companies to analyze some very ephemeral or subjective harms and somehow respond to such harms proportionately. Now, interestingly, the Privacy Bill of Rights was a bit of a missed opportunity for the White House to apply some of its own recent conclusions about privacy harms. And as I mentioned earlier, the White House had expressed significant skepticism about the long-term viability of FIPS in the face of changing technology. Yet the Privacy Bill of Rights doubles down on focusing on notice and collection and retention practices. And for the reasons I mentioned earlier, I'm concerned that in the medium and long term, baseline privacy legislation that mandates a FIPS approach is not the best way to protect consumers or permit innovation going forward. So let me briefly address one final topic. Courts faced with lawsuits about data breaches must decide if the plaintiffs have standing to sue. And Article 3 standing requires in part an injury that is concrete, particularized, and actual or imminent. Thus, in deciding standing, courts have opined on the characteristics of actionable privacy harms. Now, many of these cases have been in the context of national security or challenges to state action rather than private litigation against companies. However, courts have sustained motions to dismiss several private Fair Credit Reporting Act lawsuits based on a lack of standing, and held that an increased risk of future harm is insufficient to confer Article 3 standing. Now, other courts have disagreed or have found that the future harm is imminent enough to constitute an injury in fact. So what do these court decisions mean for policymakers? Although the facts of these cases are instructive about what harms consumers face from data breaches, court decisions on private party standing do not establish the boundaries of what the FTC considers to be a privacy harm. Standing serves a very specific purpose. It limits the role of the judiciary and implements separation of powers. It also ensures that the party before the court is the proper party to receive relief. Now, our enforcement actions serve a different purpose. We represent the interests of consumers generally. In many of our cases, the injury to a single consumer may be very small, but the overall injury across all consumers may be substantial. Because our enforcement is intended in part to fill the gap where individuals may lack the incentives or the standing to pursue such relief through litigation, it doesn't make sense for standing determinations to have a substantive effect on our conception of privacy harm. So just to conclude, as technology evolves and collection becomes ever more ubiquitous, we need to understand better what counts as a privacy harm and how such harm should be resolved, whether it's through market forces or social norms or litigation or regulation. And I know my co-panelists have thought hard about these questions, so I look forward to hearing from them. Thank you.
I'm delighted to be here, and it's an honor to follow Commissioner Ohlhausen. I'm going to talk a little bit about some of the similar things that she raised, but from a slightly different perspective. I am currently counsel at Hogan Lovells in the Privacy and Information Group, where we advise clients on privacy and data security issues all over the world. But before joining Hogan, as Glenn said, I spent 30 years at the FTC as a consumer protection attorney. I led investigations and rulemakings. I worked for a chairman. I worked for some other commissioners. And I basically lived and breathed Section 5, as well as the Fair Credit Reporting Act, which I still carry around with me in its battered state. But I am happy to be working at Hogan, mostly because it's just an interesting opportunity to apply some of the issues that I'm so familiar with in a new setting. In talking about the concept of harm in privacy matters in the context of the FTC Section 5 authority, I completely agree with Commissioner Ohlhausen that both deception and unfairness require harm in the analysis. One of the things that has been most interesting about working at the what was so interesting, I still have verb tense issues, working at the FTC was that Section 5 has proven to be really resilient over time. When I think about the issues that the commission worked on while I was in Chairman Steiger's office, for example, green claims, food claims, dietary supplement claims, and in almost every instance, Section 5 was the law that was being applied. And some people probably don't even remember that when the Telemarketing Sales Act was before Congress, the commission actually opposed the legislation. They said, we don't need it. We have Section 5 and Section 13B. So I digress. Deception, but the point is that I think it's been a pretty resilient Deception and unfairness are fairly resilient. I won't repeat what the commissioner said. I agree entirely that materiality is the injury component of deception. But I think I will tell a little story that I'm glad Commissioner Ohlhausen didn't say, because I think it's very relevant to this conversation about privacy. And that's this. The commission's experience with unfairness has not been a smooth road. I don't know how many people remember that in the late 70s, the commission came under fire for what was called KidVid. The commission had proposed a rule that would have banned television advertising for sugared cereal on Saturday morning TV. Congress and the industry complained that that the commission was writing rules and bringing cases based on public policy, because before unfairness was codified, public policy was a component of injury. So the outrage was that cases and rules based on public policy and not legal precedent provide no guidance to industry. They're impossible to follow. They can change in a nanosecond, and critics called the commission the national nanny. As a result, Congress prohibited the commission from engaging in rulemaking based on unfairness. That's when the commission started writing some policy statements, but they were not completely united. The Congress held back the commission's authorizing authority, not its appropriations, but its authorizing authority, and then eventually in 1994 created a statutory amendment that defined unfairness to have those 3 points: substantial consumer injury not outweighed by countervailing benefits that cannot be reasonably avoidable. So we're in agreement on the harm thing. The unfairness, though, as it's applied to data security, is a little bit uncertain right now. The commission is litigating the Wyndham Hotel and Resorts matter in district court. There's an interlocutory appeal. They've been waiting a very long time for that court to rule, but that will have a lot, that will provide a lot of guidance on what injury is, certainly in the data security space. And query whether the district court was the right place for that action. It could have also been brought administratively. I should also note that there's additional uncertainty in the regulatory space because of the increasingly crowded field with other agencies like the FCC and to some extent the CFPB getting into the privacy regulatory framework. And then, of course, there's the states, which everyone refers to as the laboratories of democracy. Now I'd like to provide a little bit of a viewpoint of what it was like to be a staff attorney bringing cases. I can say that there's many impetus for starting an investigation, and I started more investigations that ever came to fruition. From my experience, I think at the staff level, triage is happening on a daily basis in figuring out what is the best way to bring the right cases for the commission's approval. I focused on the Fair Credit Reporting Act cases, and although I was very aware of what was happening in that space, the first thing I did was look at the commission's database to see if there were consumer complaints, because that would tell a story of how whatever the conduct was impacting consumers. So just as all tips don't turn into investigations, not all investigations become enforcement actions. But even after an investigation, there's more review that happens before it reaches the commission level. An analysis by the Bureau of Economics and a robust discussion at the Bureau Director's office as well. There was more than one occasion when I said, but they violated the law, and the response was, but they fixed it and there's no injury. And so that is what some of the experience is like from a former staffer's level. Robbins versus Spokio is going to be really, really interesting to see what the Supreme Court does. This is the case involving the Fair Credit Reporting Act. The Supreme Court granted cert this spring. Now, Robbins versus Spokio involves the Fair Credit Reporting Act. And I agree with Commissioner Ohlhausen. It's one of the first privacy laws enacted in 1970. It regulates a specific kind of information, consumer report information. And there are 3 guiding principles of the FCRA. The first is privacy, limited use to a certain kind of information. The second is fairness. Obsolete information rolls off over time. Some obsolete information rolls out over time. And consumers have an opportunity to dispute inaccurate information when adverse action is taken. And 3, accuracy. Both the furnishers of information and the credit reporting agencies have an obligation to ensure that the information they provide or furnish is accurate. That standard, too, has evolved over time as the FCRA has been amended. Now, the FCRA can be enforced by federal agencies, the states, and individuals. When an individual brings an action under the FCRA, they have 2 choices: to establish that there was negligent conduct, in which case they are only able to recover actual damages, or willful noncompliance, which is what Mr. Robbins alleged, and in that case, the court can award punitive damages. Now, what's very interesting about the Fair Credit Reporting Act and private rights of action is that I can't count how many actions or settlements I was able to negotiate that the next day a class action was filed. And Spokio was one of them. I was involved in the FTC's action against Spokio. So as a result of this class action boom in the Fair Credit Reporting Act space, the Supreme Court in the Safeco decision several years ago said that willful noncompliance is essentially reckless noncompliance. So it's a very high standard. Just to go through where we are procedurally, the district court in Robbins dismissed the case for lack of standing, concluding that Robbins had alleged an injury in fact had not alleged injury in fact necessary to satisfy Article 3 standing. The Ninth Circuit reversed and held that Robbins had sufficiently alleged that Spokio's violation of the FCRA caused a violation of a right created by statute, and that the FCRA provided the remedy. So there's great interest on how this is going to come out. But interestingly, the Solicitor General recommended that the court not bring this case because suggested to the court that if they do bring the case, that they should focus on the specific allegations. The Solicitor General's brief characterized Spokio's argument as raising an abstract question about whether a bare violation of a statute satisfies Article 3. If the court rules in Spokio's favor and holds that to establish standing, a plaintiff must allege some concrete injury separate and apart from infringement of a statutory right, the decision would make plaintiff's statutory claims more difficult. These plaintiffs would no longer be able to rely on alleged statutory injuries to establish this Article 3 standing. They'd also have to allege concrete injury. Others have expressed concern that a ruling in Robbins' favor will open the floodgates to class action. If Robbins prevails and the matter is remanded to the district court, however, under the FCRA, Robbins must still prove that Spokio's conduct was either willful or negligent. And the information, and that may be particularly challenging because the information at issue in Mr. Robbins' case is that he had more education and more professional experience than he actually has. So it may be difficult to prove injury when that goes back down, if it goes back down. I don't want to take too much time, but I wanted to just make one comment, not about the substance of the president's bill, but of what it looks like when an agency like the FTC has to implement the rules of a piece of legislation that Congress has enacted. And that can be a very difficult process. When the FCRA was amended by the FACT Act, the Commission had to engage in rulemakings, like 19 different rulemakings, a bunch of different studies. It took a lot of time. And even though the staff and the Commission are extremely thoughtful as they go through these rulemaking proceedings, sometimes they're not pretty, they're often hard because of the limitations Congress imposes on the agency. And then I can say that the Commission does the best it can to create a rule that is not technologically obsolete. So, for example, the disposal rule, which requires that the proper disposal of consumer report information practices be reasonable and appropriate to prevent the unauthorized access to or use of information. I helped roll out this rule. It seems very simple. I could not count how many calls I received from businesses and saying, just tell me what size I need to shred my paper. Because the rule did not address that intentionally. It wanted to be broad. It did not want to become technologically obsolete, but in so doing, created a little bit of regulatory uncertainty. Before I conclude, I did want to say one thing about the NOMI matter, because I too found that fascinating. The Commission did seem to rely on this presumption of materiality in an express claim. And as a student of the FTC, I totally get how that presumption evolved. It evolved primarily in the health and safety kind of space, where an express claim would be presumed material. And as personally, and I now no longer have to say I'm not speaking for the Commission or anyone else, I can say that I question whether that kind of presumption makes sense in the world of privacy. So it is difficult to articulate the boundaries of privacy harm and the application of Section 5. While both the deception and unfairness have harm based a part of it, I appreciate that there's a sense of uncertainty by businesses and others as to how the Commission will apply that. And in my new role at Hogan, I have even a better understanding and appreciation of what it's like for industry to attempt to conform to what may be perceived as evolving standards. Thank you.
Great. Thanks very much, Glenn, to the Foundation for inviting us here. Harm is, as we've been discussing, a key component of privacy laws, of the FTC's Section 5 authority, and of how courts handle cases involving privacy violations. In my brief time, I'm going to try to talk about, our view that, the proper definition of harm in the privacy context really does turn on the context for the relevant legal framework that it's being used in, and that harm can impact individuals differently. It's a little less easy to predict harm than some, for example, some consumer protection laws, and that I'll focus on our consumer privacy legislation that we released, and we'll try to argue that we think we hit a good balance there. Earlier this year, in February, the administration did release a discussion draft of a baseline consumer privacy bill, the Consumer Privacy Bill of Rights, and as Commissioner Ohlhausen read, our definition of privacy risk does include emotional distress, physical, financial, professional, or other harm. But it's important to really kind of understand the larger context of the legislative proposal. The bill does require companies to take reasonable steps to protect consumers' privacy in light of those harms, but the bill is, frankly, an entire construct of kind of flexibility and tailoring to particular context. So the law does not require that companies prevent all possible harms, but to ensure that entities' collection and use of data is guided by some common sense baseline principles. Essentially, the mandates of the bill, the companies need to act reasonably in light of the risk of harm. So there is an enormous amount of flexibility in the draft proposal. The entire proposal is really geared toward encouraging industries to create codes of conduct to specifically address their particular context, their particular industry circumstance and market circumstance. And in those processes, the definitions of harm can be fleshed out. There's certainly a lot of circumstances where something that might be harmful in one case might not be harmful in another case at all. I mean, just taking location information from an online app. I mean, if you have an online app that is constantly tracking me 24/7 and reporting it to various individuals or entities, well, that's something that could, in fact, be a significant concern from a harm perspective. On the other hand, if you had an online app where the only thing it does is tell me where the closest coffee shop is, and then it discards the information, well, that app, knowing my location, there's very, very low risk of harm in that circumstance. And so, I mean, even though physical location is, in many contexts, a sensitive piece of information, what we've tried to do is to create a legal construct that tailors the obligations on the companies to the real risk of harm in a circumstance. And so, with the a 24/7 location tracking app, we would certainly want a high level of consumer understanding of what's happening to that data. But with just an ephemeral use of location to find the closest coffee shop, we actually would go and be less than the FIPS. We would suggest that there isn't a significant need even to give notice to say, hey, I'm about to collect your location. So the kind of the risk of harm under our statute really does is applied in a very tailored manner. But I think kind of stepping back to try to kind of address the topic of the day a little bit more broadly, I mean, I think it's actually useful to compare the FCRA, the Federal Fair Credit Reporting Act, with our draft legislation, and then also I'm going to add a third one, the administration's data breach proposal, because I think if you look at all three of the provisions, you see different handling of the concept of harm, and in my view, appropriate handling of the concept of harm. So in the FCRA, you have the FCRA that is focused on some very specific and very well accepted harms. In terms of financial harm and the like. And you have then the FCRA imposing very specific and not, frankly, very flexible requirements on companies. So when we have a circumstance, when we have a legislative document, a law that is addressing very concrete, very well identified harms, it's certainly appropriate to impose very concrete requirements. Then you look at the privacy baseline privacy proposal that we released. That has a broader definition of harm. It addresses a broader set of harms. It does include things like embarrassment, but the obligations it imposes are very flexible, and the industry is able to tailor them to the particular circumstance. And so it is a much lighter weight set of requirements that really can, be tailored to circumstances. And I mean, unlike the FCRA, which is focused on very specific industries, very specific actors in the marketplace, our baseline bill is focused on all online actors and all offline actors. And we frankly think it's kind of impossible to, when you're doing a baseline bill that covers everything, to concretely predict every possible harm. So we wanted to have a fairly broad set of harms covered, which then, in the code of conduct process, would be able to be tailored to the particular circumstances. And then just to contrast, thirdly, the administration's data breach proposal, and that proposal refers to harm, requires that companies, in the event of a data breach, provide notice to the affected individuals unless there is no reasonable risk of harm or fraud to such individual. And that proposal doesn't really categorize what types of harm we're talking about. It's actually really quite general, in contrast to, say, to the FCRA. But the obligation imposed on the company is relatively lightweight. It's really just a notification obligation. Now, that's I don't mean to say that doesn't have some burdens on the company, but compared to the obligations imposed in the FCRA, it is a much lighter weight burden. And so my suggestion is that a different approach to harm in the different legislative context is a perfectly appropriate kind of way to think about it. It's also the case that the kind of differences between the FCRA and the administration's draft bill, does kind of in part turn on really a difficulty of identifying exactly what harms there are. And so in the FCRA, it addresses very concrete harms that are probably going to be harmful for most people affected. In other words, if your financial data is misused in a particular way, if you lose a job from it, if you fail to get insurance because of it, it's very easy to understand that that harm. And so a very concrete, fairly rigid top-down set of rules may be an appropriate response to those very concrete harms. But in the privacy draft legislation, it is a broader, more subjective list of harms, but it is also allows a more tailored response so that the obligations can be, in most cases, much lighter. And so there really is, again, a difference between how specific a harm is and what the regulatory burdens are. And I'll wrap up just to kind of make sure I don't take all of Adam's time. Just with a couple of comments to somewhat respond to Commissioner Ohlhausen's comments about the draft privacy bill doubling down on the FIPS. I actually think we have a quite different concept of it. We think while the FIPS are a very important guidepost for privacy conversations in this country and around the world, our goal was to try to reduce notices where actions were in context. In other words, where a consumer would fully understand and expect a company to obtain certain data and use it in a particular manner. We actually would urge that very less notice needs to be given where the company is doing what's expected. And it's only really when the company is acting out of context in a way that would surprise users or not be something that a user would reasonably be able to predict, then we come back to say, no, you need to provide more notice, more control, more understanding. So, I think that we've tried to tailor the kind of impact of the legislative proposal in that manner. Let me just comment finally, and before I wrap up, on the kind of the question of deception in the NOMI case. I express no opinion one way or another on NOMI, and I certainly am in no position to kind of suggest one way or another how the FTC should exercise its prosecutorial discretion in terms of its own resources. Those are very important conversations for the Commission to have itself. But I would say, just as a general matter, that to the extent that we are going to have a privacy approach in this country that has notice as an important component of that, and certainly that's what we have now, and I think that will never be able to get away from providing some notice in many contexts, then I would suggest it is really very important to also have a robust deception framework. In other words, there's no question that consumers are choosing between a lot of different choices. We can't sit here and predict why are they choosing this company versus that company. And if one company is making certain promises and another company is not making promises about how data might be used, for example, then we actually do think it's important that the company that is making the promises be held to those promises. Because if we adopt in this country a mode where companies can say things, and as long as the company believes, well, gosh, there's no harm going to flow from it, the companies don't have to worry about whether that's a truthful statement, then I actually think the end result will be to reduce consumer trust, and I think that in the end will be bad for industry and bad for consumers. So thanks very much. Look forward to discussing further.
Well, good afternoon, everyone. Again, my name is Adam Thierer at the Mercatus Center at George Mason University. I want to thank Glenn and Washington Legal Foundation for inviting me to be part of this excellent event. I'm going to make some off-the-cuff remarks based upon the substance of some recent law review articles I've recently done in the Harvard Journal of Law and Public Policy, the George Mason Law Review, and the Maine Law Review. These are all available online, but I figured today I would just come here and read them word for word. No. Okay, bad idea. So I love this topic. This is a terrifically interesting topic for me because I started out life 30 years ago studying philosophy. And, when you study philosophy, the first thing you start by looking at is metaphysics, and eventually you get your way to ethics. And of course, the question of what privacy rights we have or privacy obligations is really an intersection of these questions of metaphysics and ethics. So it's terrifically interesting to me, but it's also terrifically frustrating and difficult. And I spent a lot of time, like a lot of other people who've been involved in ethical philosophy and these issues, trying to struggle, to find that perfect taxonomy of rights and sort of where our privacy fits into that conception of rights. And let me tell you something you all already know, which is that's damn difficult. It's perhaps even impossible. And what I've suggested in these law review articles is that because it's impossible, we may need to find a different way of addressing these practical concerns about privacy, even if we can't come to an answer about exactly what our privacy rights entail. So these law review articles are really inspired by work that I did as a much younger guy in the field of online child safety and free speech issues, some of which I did with a certain radical gentleman who bears a striking resemblance to the man who sits right here. He and I filed quite a few amicus briefs in the courts through the years and did other work together on free speech and online safety issues. And I'll tell you a quick story that's relevant to the question of privacy harms that comes from my experience in the field of online safety and free speech issues, which is many, many years ago, a scholar from Israel came to visit me because he had seen some work I had done, a law review article and some subsequent writing, and then he had seen an amicus brief that John and I had filed somewhere, I think in an appeals court. And he said, Adam, you got to help me understand the American conception of online safety and free speech and how these things intersect, because it seems like you Americans really have kind of an extreme view of these things to the point where, you have no laws governing hate speech and very limited rules governing like online access to pornography and things like this. He's like, can you bring it all down to a phrase for me of like how Americans think about online speech and online speech harms? And I said, yeah, I think I can with a nursery rhyme. Sticks and stones may break my bones, but words will never hurt me. That really describes almost perfectly the way we think about speech in the United States, that words don't do harm, that physical actions do. Now, that's not a perfect adaptation or explanation, rather, of American jurisprudence, but it's pretty darn close. The Supreme Court in this country, in so many cases, has basically said you can say or express yourself almost any way you want, sometimes going so far that I think I've held back defending things. I think there was the Stevens case that involved kitten-crushing videos, and there was a case on virtual child pornography. I think those are the ones I did not sign on to your briefs, John. I think I was out of those. But, generally speaking, we go pretty far in America and say you've got to have a pretty high standard or test before you can restrain speech or expression. And for better or for worse, I'd like to suggest, and I do in my work, that that's largely our standard for privacy. That it is a sticks and stones kind of an approach and words don't hurt kind of test, Because generally speaking, with some notable exceptions that I'll get to in a second, we basically say that you're free to collect a lot of information about others, observe others, to report that information. A lot of that's because speech in this country and information flows in this country are governed, of course, by the First Amendment. So to the extent we want to talk about fair information principles, just to repeat a line that Eugene Volok's developed in some of his work, the ultimate fair information practice is the First Amendment. Information shall flow freely. So that creates a serious challenge for us because it very much limits what the law can and maybe should do to deal with what may be very legitimate privacy concerns. In the same way, the law already limits what we can do to address what some people may feel are very legitimate concerns about online access for children to pornography, or to all adults to hate speech, or to bullying, harassing speech. So how does this play out practically in the law? Well, for both online safety and for privacy, the way it plays out is we very narrowly target what we regard as the most sort of egregious forms of harm that generally do involve threat to body, or to property, or to pocketbook. And we make those sort of a special class of safety or privacy rules. And we have a body of law that's developed around those. Again, quite limited in its scope and in its enforcement powers. And the rest of it, we basically don't say quite anything goes, but somewhere darn near close to it. Now, this is a very different conception of speech and privacy rights than, say, the Europeans or other countries and continents, right? But I want to suggest that it's not necessarily a bad one, that there are many benefits associated with that sort of being our philosophical baseline. And for many years, I struggled to figure out, well, how do you construct that same vision using, a conception of rights or whatever else? But practically speaking, I now think we're at the point, and I suggested this in 2 of these 3 law review articles, that even if we could come up with a perfect conception of what our privacy or safety rights look like, in certain cases we have to think about the fact that it's practically difficult and almost impossible to enforce those conceptions of rights in the modern information age. That the free flow of information, the sheer volume of information, its quicksilver nature and how fast it flows, make it increasingly difficult, if not impossible, for us to enforce sort of a top-down kind of control regime on speech, whether it's speech of an objectionable nature like pornography or of a privacy invasive nature. Now that's going to make a lot of people uncomfortable. The most interesting thing about these debates to me is that I've spent the first half of my life arguing with conservatives about how uncomfortable it makes them because of the fact this means like we're going to have a lot more porn and a lot more hate speech, a lot more other things. And now it's sort of folks on the left who are saying, but it means our personal information and our dignity is going to be abused by the nature of the fact that all this information is out there on us. Yeah, there's something to that. I agree with that because I happen to be an extraordinarily private person. For God's sakes, as a libertarian, my life philosophy can be summed up as leave me alone. And so, frankly, I try my damnedest to get everybody, not just the government, but corporations and everybody in between, just to stay out of my business, stay out of my life. And it's challenging. And there's times I want to assert my personal conception of privacy out there and say, hey, you should leave this out of it or leave this alone. But I know that's probably not only not right, but it's also probably not practical. So I think we have to be far more concrete about what we know to be very legitimate concerns about harms to self, property, pocketbook, things like this, and get concrete about that. And I think what you see in the FTC's test that's already been well explained here by Commissioner Ohlhausen and Katherine Armstrong, we see that sort of conception in the FDA's test of harm. It's a very limited one. And it basically says, the emotional stuff, no, that's not part of it. And we see that in American law as well. Now, let me get back to the exceptions, because there are exceptions. There are exceptions in the field of free speech. The whole field of defamation and libel, right? There are emotional harms there. Those are psychic harms, right? But they relate back to the fact that ultimately they can be monetizable in some way, or they can be concrete, and that it can degrade and devalue something else in your life. Your value is an employment or whatever else. But regardless of how you want to conceptualize that, it is extraordinarily limited. You got to prove actual malice. That's extraordinary, right? And you think about other limitations on, like, hate speech, almost none, or speech in public places. The proverbial can't shout fire in a crowded theater. And we have very limited time, place, and manner restrictions on speech. These are pretty good tests. They evolved over time. Well, we have those same tests and approach, I would argue, in the field of privacy law. And I think they're pretty good ones. I think if you look at how our torts have evolved, there are some rights that you can exercise based upon intrusion upon seclusion. And sometimes we even have targeted statutes, like peeping Tom statutes, that say you can't go take pictures of people in a state of undress, with, in a locker room or under bleachers or something. These evolved over time, and I'm all right with these. But for the most part, we haven't adopted this sort of overarching approach that basically says we have a clear idea of what privacy harm entails, and given the context, it will be applied in all of these different areas. I just think that's too murky, and it's not going to work. I think instead what we need to do, and again, to go back to the field of online safety and child safety concerns, is we need diverse solutions for a diverse citizenry. We need to think about a toolbox of approaches that we can utilize to try to solve these hard problems without resorting to any answer that involves, like, here's our overarching theory of privacy harms. Instead, we'll just say, different people have different privacy issues and concerns. What can help solve those? Well, I'll borrow from the same toolbook that I've utilized in my past work on online safety, much of which I developed with John, which is that you start by utilizing educational-based approaches. You use things like digital literacy and digital citizenship. You have not only private actors and educators get behind that, you have the government get behind that. Talk to people about privacy concerns, privacy vulnerabilities. You use empowerment solutions is another second tool we have. You give people more and better tools to protect their privacy. Certainly we have a healthy debate going on in this country over encryption. We have an administration that's a little bit conflicted about these issues, to say the least. But stronger encryption is just one of many types of tools. There are many other types of safe browsers and other things like this that you can utilize. Industry self-regulation, codes of conduct, best practices. This is something that the administration, this current administration, has done a lot of good work on to develop these things. Joe Jerome's in the back of the room from Future of Privacy Forum. I always give these guys a lot of love because they develop some really interesting and excellent best practices for industry to follow in a wide variety of different contexts. I applaud that. Now, what beyond that? Because you say, well, that's not enough. Well, we've already heard a lot about Section 5. Section 5, in a very targeted way, goes after those concrete harms that everyone, at least in these states, can agree probably need to be actionable. I won't reiterate that except to say we have state actors and state laws. We also have AGs that are always willing to pounce, and we have a very healthy class action bar in this country. And then we, of course, have targeted laws. When all else fails, we say, okay, we really do need to narrow it down because this one is really bad. I don't quite understand how we got to that with video rental records, but we did. But we have it for financial and health, right? And we also have it for children with COPPA, for better or for worse. And I'm going to leave COPPA out of this for a second, but I've done a lot of work on COPPA. But the point is that we've narrowed it down. And again, you can go back to the idea that in an American conception of privacy, those have to do with harm to body, harm to health, harm to pocketbook. Easier to tether those privacy harms to harms that are traditionally more accepted. Now, beyond that, there needs to be something more said, and I'll wrap up on this point. I know I've run long. There needs to be a final word said about the importance of social adaptation and acclimation to new technology and culture. Because whether we're talking about online safety and speech, or whether we're talking about privacy, things change and people change. There are things said in our country, in the aisles of supermarkets today by average housewives, that would have been unthinkable in the 50s. And yet, that's the world we live in. Things are freely said in public spaces of a very vulgar and sometimes sensitive nature. There are likewise things shared in our country today, namely every day on Facebook, that would have been outrageous to share just a generation ago. Norms change. People change. Cultures change. We acclimate ourselves to new technologies and new developments, and our notion of harms change with it. I mean, all you have to do, and I've written about this a lot in my law review articles, is go back and read that famous 1890 piece on the right to privacy by Brandeis and Warren. To me, it's an extraordinary paper for many, many reasons. One of the most influential in the field of law. But it's extraordinarily in particular because of the way they wring their hands about the camera. And the fact that, oh my gosh, there's this thing now that can come out and take our image and take it from us, or take it from our family members without our permission, without our consent. What are we going to do about this? They said, what are we going to do? Well, we had our answer within a few short years as Americans. We were all going to buy one. We were all going to bring the camera into our lives and make it part of the American experience, right? It became an essential part of who we were as a culture. You flash forward 100 years, You think about the experience we had with new technologies, ranging from geolocation technologies or something like Gmail or things like this. Early on, a lot of these technologies, some privacy advocates said, we got to ban this. We got to stop this. This is incredibly invasive. Within a few short years, we're all like, well, this is pretty important. It serves a great function in my life, provides greater utility, does it at a good price, usually free. And so our norms and our societal values changed. And so that's the other reason I'm skeptical of efforts to have sort of let's have a clearly defined theory of privacy harm. I just don't think it's possible. Let's find constructive solutions to complex problems by working from the bottom up as opposed to creating sort of a top-down framework. Thank you.
Thank you to all of our speakers. I wanted to give each of you some time if you wanted to refer to anything that was said by the subsequent speakers, Commissioner Ohlhausen or Armstrong. Do you want to have anything, make any suggestions or statements on what you've heard so far?
Sure. I think just picking up some of Adam's points, I think that the utility of having both deception and unfairness does allow for this change over time, and the fact that people value their privacy preferences very differently. So unfairness kind of has these baseline protections, whereas we also have deception. So if there are consumers who have more sensitive privacy preferences, they can go out in the marketplace and choose services or devices or providers that provide that different level or higher level of protection. John, I just want to clarify my point in NOMI wasn't that we should just give people a free pass if they had thought, well, I'm going to do this, I'm going to make this promise and I plan not to adhere to it. It's if it was an oversight or an error in trying to provide a higher level of privacy than the law required.
No, I would just say that I really agree with Adam's point about changing norms, and the thing I think about with that is that a few years ago we would have found it sort of very scary that Amazon would tell me what books I might like when I have no idea what I want to read, and that used to be scary, and now it's kind of almost appreciated. But that's an example of an evolving norm.
So I think this is all, responding to Adam. I want to counsel my good friend Adam to not give up on his libertarian desires to be alone, and to suggest that, just as 100 years ago or even more, yes, our society did adjust to the camera. It was confronted by the camera. It had a lot of overreaction to the camera. And we figured out that it's a great technology that does have some privacy risks to it, and we addressed those privacy risks in very discrete ways. And I frankly think that's what we're doing now. I think that the internet and online services have enormous value for our society, and yes, they also do raise some privacy risks, and we're trying to look for kind of the ways to respond in the discrete areas where we need to respond. And I couldn't agree more with Adam from a First Amendment perspective that our general goal should be to allow discourse and discussion and use of information if it's been made available. So I think I agree with Adam, but at the end of the day, I would suggest that there are in fact things that we as a society need to try to address and figure out. Completely agree that we should do it in a bottoms-up manner. That's what the Consumer Privacy Draft legislation tries to do. And so, so I'm with you, Adam. Just hold out. We'll allow you to keep yourself private.
I guess my only response to that, John, would be is that the difference is when you talked about how we had the camera, we got along with it. We did it in a very targeted way when we did address the harms, right? So you look at like anti-paparazzi law or peeping Tom laws. You came up with a narrowly targeted concern and said, okay, we're going to zero in on that, right? We didn't have an overarching consumer bill of rights for cameras. nor did we have more recently, when we were doing our work together on online safety, an overarching online safety comprehensive Bill of Rights for children. I mean, there were people who proposed these things. But we opposed them because we said that's the wrong way to think about it, or the wrong way to approach it. Let's find solutions to the tough problems, but understand you can't have an overarching one, and that's the difference here. I mean, the administration setting forth the sort of overarching top-down kind of vision. Honestly, I could argue about it philosophically why I don't think that's right, but I just think practically it's not going to be workable. Even if you say, well, it's all context and we'll work it out later, and then that creates a lot more uncertainty in law, and you know, there's all sorts of innovation issues here I didn't go off on. I did write a new book on permissionless innovation, if you might want to read, that talks about that value. When you balance values, it's not just like speech versus privacy. There's a tension there. There's innovation versus privacy. There's a tension there too. And you know, I think the overarching approach, I hate to say it, the Europeans have been down this path. And economists and political scientists love what are called natural real-world experiments. You look out at the world and say, here's a country with one set of policies, here's a country with another to address the same issue. Which one worked out? The European Data Directive in that approach for the last 15 years has stifled innovation on that side of the Atlantic. Our approach here, again, based on permissionless innovation, I think it's worked some real magic. And that's why I'm always troubled by these arguments that are made by the administration and others, like we need a comprehensive framework to achieve trust and grow the economy. Our economy's growing like gangbusters when it comes to information technology. That's the least of our problems. I think the problems that we've created in this country on privacy front are precisely because the internet economy's grown so fast. So we don't have a trust barrier because of privacy or regulation or lack thereof in this country. So I just throwing that out there for thought.
Be happy to take your questions in the audience. Just remind the online viewers that you can email interactive@wlf.org and we will address your questions. Do we have any questions from those who are here with us today in person?
My name is Richard Samp. I have a question for Katherine Armstrong or anybody who wants to talk about Spokio. I gather that the Supreme Court's only decided the question of standing, but to me a basic issue that Spokio has raised, but is not before the Supreme Court, is whether it's covered by the law at all. My impression is that on the one hand they're potentially being sued for billions of dollars of damages, but on the other hand they say, look, we're not a credit reporting company. All we do is collect some information. We don't try to claim that there's anything. We don't verify the accuracy of the information. And the kind of complaints that I oftentimes hear from companies is, we really want to know what the law is ahead of time, and we don't like the FTC to come after us and tell us that, well, what you did was a violation of the Fair Credit Reporting Act, or you didn't adequately protect your data from breaches, and the only way we know that potentially we're violating the law is because the FTC has come after us. And I'm wondering what the FTC does to try to establish rules ahead of time so people can know what they can do to comply with the law.
Well, with respect to the Fair Credit Reporting Act and Spokio in particular, at the time the Commission brought its action against Spokio, they were marketing the materials that they were selling to human resources departments. So that would, the Fair Credit Reporting Act requires consumer report information, which is almost anything that comes from someone that assembles and evaluates it, which was Spokio, and that is used to make an eligibility determination, which employment is one of those factors. So Spokio did argue that they were not a consumer reporting agency, but they did end up settling with the Commission, and then Robbins brought the action. So that is your, asking a fascinating question. I mean, this is an opportunity too soon for the court to rule on that issue because it's just a procedural, essentially a procedural issue about whether or not they're standing. But the Fair Credit Reporting Act is, you're either in or you're out. It's either consumer report information coming from a consumer reporting agency, or it's not. Although the world is getting a little more complicated, and there's a lot of stuff that is almost as good as a credit report and could be used for a particular eligibility type purpose, but may not fall within the specificity of the statute itself. Does that answer your question?
Any thoughts further on Spokio? Any other questions from our audience? I guess I will weigh in with one then. How much do you think about the concern about defining privacy too broadly and diluting the concept of privacy in general, sort of the dilution of something by defining it too broadly? And I think that probably, if you define harm of privacy too broadly, I guess is what I mean, but if you dilute the concepts of privacy and sort of everything becomes a privacy violation. How much do you think about that as regulators, and how much do you think about that in the context of trying to help those that are trying to comply with the law? I just kind of throw that out there to anybody in general.
I'll take a crack and say, I mean, frankly, I think we think about that a great deal. I mean, not in the kind of abstract manner that you posed the question, but in I mean, frankly, you know, I completely agree with what one thing Adam, his last point, which is that we really are balancing innovation along against privacy on some level, and I mean, certainly the Department of Commerce wants to be promoting vigorous, robust innovation, and you know, we try to develop a framework that does include things broader than the FCRA harms, but that does not, you know, in our view, really stifle innovation. You know, we think, again, in the kind of bottoms-up tailored code of conduct method, that innovation would very much be able to flourish. I mean, so I mean, it's not a question of, for us, you know, gosh, we're going to diminish privacy if we go too broadly. But I mean, what do we need to do to address privacy in a meaningful way, but still allow innovation? And I would suggest that, I mean, you know, there are a lot of studies that indicate and have indicated over at least 5 or 6, 7 years that consumers are still hesitant to go online and do business, that half of America is doing that and half of America is not, and they cite privacy anxiety and concerns. And so, I mean, I think that, you know, in addition to the kind of goal of saying, let's try to protect consumers' privacy, I actually think if our goal is to promote economic growth and economic innovation, I think we also want to have a privacy framework.
Inherent in the FTC's, or explicit, I should say, in the FTC's unfairness approach is this balance. So our job is not to define privacy one way or the other. Our job is to advance consumer welfare. And one of the tough issues is where you have something that on one hand can be seen as harming a few individuals, but on the other hand, it is good for competition, or it's good for consumer welfare overall. So when you think back, again, why I like the Fair Credit Reporting Act, for an individual consumer, they may say, you know, it's not so great for me because there's bad information about me and I'm going to get a worse deal because of the fact that people have this information, can use it to make a decision on me. But we've made a decision as a society that that's actually better for consumers overall. It's better for competition overall, that we actually make that trade-off in that way. So I think one of the things about looking at the practice and saying, on balance, does the harm of that practice, is it outweighed by the benefits, not just to the consumer, but to competition as well, tries to get at some of these issues about the effect on things like innovation, competition, or consumers more broadly.
I think one of the biggest challenges is the range in consumers' opinion, because there is no real one-size-fits-all. And it sort of reminds me of the food label, which was such a great idea in some ways, although not perfect in others. But the concept was that consumers generally care about these things: salt, calories, sodium, fat, you know, whatever. And the food label was sort of meant to be kind of this universal thing that if you cared about salt, you could check it, or whatever. I think the challenge with privacy is that it's hard to to create the categories. And even in the food space, it was incomplete. And it's never going to be comprehensive in the privacy space. So it's difficult to balance the different kinds of privacy issues with the different views that consumers have, because it's not united.
Yeah, I agree with all of that. No doubt about it. This is, the problem with defining privacy and safety is that it's sort of the ultimate eye of the beholder problem. It sort of comes down to sort of classic, I know it when I see it test, right? So it's a real challenge. But let me say something that counters what I've said earlier, and in defense of the administration and a lot of the people I often critique on this front, which is I don't think we've reached the point here in the States yet of trying to define privacy too broadly, generally speaking. I think if you want to see that, you go and look at what Europe's doing. Because they have such broad-based notions of privacy now that they're getting into these things like right to be forgotten and, search histories being, being censored. I think that's a totally different kind of league of conceiving of privacy, and we're not there. I think, generally speaking, I like the idea of looking at it in a contextual way, like the administration's done, like a lot of American privacy scholars have done, and think hard about constructive solutions to these. Ultimately, I probably disagree about do we need a legislative or regulatory approach as much as others do, but I think still our country and our culture has a somewhat more reasonable approach to this that hasn't diluted the concept entirely yet the way the Europeans had, and made it trump every other value there. That's the really concerning thing in my view, is that it trumps everything else in Europe, and there's almost no trade-offs discussed. So.
Any final questions from our audience? I want to thank everyone for joining us today. Commissioner, John, Adam, and Kate. And this is going to be on our website as a